You're live.
Okay. Somebody has arrived here at my home, so I'm going to mute myself with the dog barking and let the vice chair take over for a few minutes. But our first witness is Jay Johnson, and I'm sorry for the background noise.
All right. So, first witness, if you want to join us to talk about S4.
Morning, Mr. Chair. For the record, my name is Jay Johnson. I'm the Governor's Legal Counsel. Thank you again for having us back to discuss S4, and I'm assuming our proposal with respect to delinquency and youthful offender. And I'm not completely sure, but if we have time, maybe some of the drug modernization initiatives that we proposed. So that's, I think, what we hope to cover today. Really, I have the subject matter experts here and on the phone, and I really am hoping to keep my remarks brief. So last time we had the opportunity to introduce elements of the Governor's Comprehensive Community Violence Prevention Package, as well as comment on S4. And today I'm happy to be here with, again, my colleagues who are going to be able to flesh out those proposals, some of those proposals as we've drafted them. I also, to the extent that there are drafting errors, maybe terms of art that I have missed, I would assume responsibility for all of those, and you're open to corrections. Again, we're here because we share concerns with crimes of violence associated with juveniles. As Dee Barbick, the Governor's Director of Community Violence Prevention, explained last week, the Governor's Violence Prevention Task Force was broken into 3 teams to address major policy areas, which included modifications to criminal laws in Title 13 and Title 18, juvenile and youthful offender laws to both address violent crimes and improve process and outcomes for youth, violent crimes committed by people with mental illness, school safety, and universal sealing. And I believe that we are really just talking about juvenile and youthful offender laws. And again, if we have time, I'm hoping some of the proposals we've made to the criminal laws. So my plan for me is to give a brief introduction of where what we have proposed, and then give the floor to my colleagues who really are the subject matter experts and can answer your questions about process, what they're seeing on the ground, those kinds of things, how the law works in reality as it's applied, those kinds of questions. So this is what we're experiencing in many of our communities, and this is what we're trying to address. So we have youth under the age of 22 who are violent, often have firearms and other dangerous weapons, and often come from out of state. This is not to say that it's all youth. It's probably a substantial minority of the youth that we are seeing these kinds of issues with. And our systems work great and are designed to address the needs of youth with issues that are not particularly the kinds of issues that we're seeing today. Our law enforcement services across the state are seriously diminished. We don't have human services staff or resources, including a facility for placing violent youth, to adequately provide rehabilitative services to some of these youth. We have a judiciary with a tremendous backlog, and we have, excuse me, a legal system that many view with frustration as a catch and release system. Our youth are smart enough to know that when there are no consequences for their actions, there's very little risk to engaging in bad behavior. Many, again, are responsive to treatment, to just being arrested. But some realize that just being arrested has very few, if any, consequences, and there may be some, benefit to continuing some illegal action. Drug traffickers know that Vermont is open for business. So those are broader issues than what we're addressing today. And the issue statement that you've received, and I believe, was posted online, takes what we believe to be some steps needed to improve our systems, to give prosecutors the tools to use when needed to move violent juvenile offenders into criminal court for a wider range of violent crimes. As you know, this is just right now the Big 12. The Big 12 doesn't address things like aggravated domestic assault, which is an issue I think that we are seeing in many cases with youth. That's very concerning. We hope to restructure our youthful offender system to create a process where youth who demonstrate they are amenable to treatment, which I think is essential for the success of our youthful offender system, can receive the benefits of youthful offender treatment in a timely fashion. And again, update our criminal laws as needed to address the violent crime we're seeing that is associated with drug and human trafficking. And again, Senator Sears in S4 has attempted to do some of this. We have some other proposals as well. Before I hand over the microphone, one specific note I would like to make relates to page 22 of the handout, which the first page says issue statement. And page 22 is virtually like the third to last page. But basically there, what we have proposed with respect to 33 DSA 5287, which is a section that relates to termination or continuance or probation. It provides for expunging records. And I am proposing in this section, which would be sort of the initial take, I think, that I have on sealing. And I would modify that expungement reference to sealing. And what I have done in this draft for your consideration, which you can see really on the next to last page and the last page of the draft, are a list of 9 purposes for which records would be available, including the defendant and the defendant's attorney, any court or state's attorneys for the purpose of pending criminal action, federal and state law enforcement agencies when acting within the scope of their law enforcement duties, court, prosecutor, and defense counsel if the defendant becomes a witness in a criminal proceeding, or the claimant and respondent if the defendant becomes a witness in a civil proceeding. When an individual is a defendant in a criminal action and the sealed records of the defendant are integral to their defense, entities that are required by state or federal law to request a fingerprint background check, criminal history information, any prospective employer if the defendant seeks employment as a law enforcement officer, any federal, state, or local agency or officer with responsibility for the issuance of licenses to possess a firearm, or with the responsibility of conducting background checks, and for purposes of civilian investigation or evaluation of civilian complaint or civilian action concerning law enforcement prosecution actions. So you see that when we have a system of expungement, it affects a number of people, including defendants, including employers for sensitive positions, including employers of police officers, and of course, NICS system background checks for purchase of firearms. This list intends to address all of those situations. We understand that there's a lot of concern with the availability of records and criminal records, but the fact is, if you have a system of sealing, you can seal records sooner, you can seal records for a broader range of crimes, and you can access those records for a number of situations which don't solely relate to use by law enforcement. So this is the sort of the intro to where I would like to go with sealing generally, but this particularly relates to this section in Title 33 related to probation. So anyway, I don't know if you have any questions on that.
Well, I'd like to make 2 or 3 comments. Thank you very much for the explanation. We are concerned about youthful offender 2 and the ping pong issues that you brought up at our last meeting. And Erica Mathage and Marsh and Paul have agreed, I believe, have agreed to work with me to see how we can deal with some of these youthful offender issues that you've raised. One of my concerns with this proposal at the end is the youthful offender system was set up similar to a deferred sentence. And we want people who are amenable to treatment to take advantage of it. I don't know how this would impact their willingness to take advantage of it. That's one thing that I would want to look at, this new structure. But we certainly will consider everything. As far as the increase in the crimes that would be part of, well, the Big 12 or big whatever we end up with, there's, I think we need to go over them and look at them issue by issue, and the committee's certainly willing to do that and consider your suggestions. But if you have specific cases where you've heard from people that these are creating public safety issues by not being able to be charged in adult court, we would be happy to hear of those. In other words, do we have cases of aggravated domestic assault which aren't being dealt with appropriately under the current system? What are they? I would hate to get us in a position where two brothers fighting it out, 15 and a 14-year-old brother fighting it out, and becomes aggravated domestic assault and a big offense or an adult charged offense.
Thank you, Senator Sears. I understand your concerns, and we're very happy to work with you and Erica and Marshall on the ping pong issue. I think that Lindy Boudreau is going to be able to speak to that, the process and what's going on there in reality today. So further questions, I think, could be addressed to her. I think Lindy, as well as maybe Tucker Jones and Jared Bianchi, are prepared to discuss specific examples of where these tools would make a difference in our current system. So, really, I would turn the floor over to the next group of witnesses for your consideration.
You also have a proposal to delay the 19-year-olds into the raise the age category. Is somebody speaking to that today, or is that for a later?
Yes, actually, that would be the first witnesses. That would be Erica Radke and Dr. Chen.
Okay.
And
well, thank you very much.
I'm just going to have to leave at 9:30 for a doctor's appointment, but I thank you so much for your consideration.
Thank you.
Yes.
Harry, and do you want Annika at the same time? She's on Zoom.
Good morning, Senator Sears. I think Erica's on Zoom, and if, I will, as needed, will chime in and provide background.
Okay.
So, good morning, senators and Chair. I'm here. This is Dr. Harry Chen, Interim Commissioner of the Department for Children and Families. We're on the phone or on Zoom, include Erica Radke, Deputy Director of Family Services, Deputy of Family Services, Lindy Boudreau, who you hear from later, who is our Juvenile Justice Director, and I expect that Tyler Allen, the Director of the Adolescent Services, will also join us shortly. DCF was tasked with implementation of the first legislation in the country to carve out juvenile jurisdiction for emerging adults, understanding the brain science as we know it. Raise the age, increase the juvenile jurisdiction in Vermont for delinquencies to age 18 as of 7/1/21. This means that as of that date, most young people accused of breaking laws at age 18, excluding the more serious offenses, were prosecuted in the Family Division of Superior Court rather than Adult Criminal Division. With supervision and coordination of services provided by the Department for Children and Families, DCF, rather than the Department of Corrections. Principles and intent behind Raise the Age are to improve outcomes for youth, increase public safety, and reduce costs, given the high rates of recidivism of this population one can find in the adult criminal system. No one could have predicted the pandemic or the impact of staffing shortages and their effects on Vermont's system of care or the courts. For these reasons, DCF has faced its most challenging year in recent history with regards to placing children and youth within their appropriate level of care. Likewise, many residential programs are operating at the limits of their capacity, either in purpose or census, creating blocks in the line of DCF's system of care. Increased pressure on the more secure levels of Vermont's system of care has created placement challenges for providing adequate services for emerging adults as well. Courts have had case backlogs, which have contributed to delays in the system. Because of this, because essentially it's an acknowledgement of our limited ability to address an increasing population, potentially one that is demonstrating increasingly violent and risks related to public safety, that the department recommends that the state defer the July 1, 2023 implementation of Raise the Age until such a time as the state has developed the facilities and programs consistent with a robust functioning system of care for existing populations before new populations can be added to the system. In our minds, the system requires at a minimum an operational, secure stabilization program for youth, community-based organization, bed and care capacity at near pre-pandemic levels or at pre-pandemic levels, a data system that could adequately track the cases that we already have, as well as those that are coming to us. A significantly improved employment market is also ideal. It's fair to acknowledge that some of the conditions described here are not directly attributable to the needs of 19-year-old youths incurring delinquent charges. However, those youth would be relying on oversight from the FSD workforce. A workforce that is presently called to far exceed the written descriptions of their duties while attempting to meet the needs of the populations that we are currently mandated to serve. The elements identified in the Act 60 report reflect those elements that most impact our workforce's ability to serve children, youth, and families. DCF is concerned if our mandate expands, this will have detrimental impact on those already within our care and present purview. It's notable that Family Services Division workforce is presently under capacity, and as is the workforce of other sectors that we partner with and rely upon, including our entire provider network, law enforcement across the state, designated agencies, hospitals, and more. While DCF holds firmly to the vision of expanding the jurisdiction of youth justice, to do so without consideration of the present reality and its feasibility risks progress itself. So thank you very much for your consideration. I don't know if Deputy Commissioner Radke has anything she would like to add at this point.
No, not at this point. For the record, I'm Deputy Commissioner Erica Radke with the Family Services Division of DCF, but I'm happy to answer any questions that the senators may have.
I have one comment and two questions. My comment is we're solving a problem for DCF if we delay the implementation of the 19-year-olds until 2025, but we're continuing a problem for DOC, or Department of Corrections, which is charged with then dealing with those 19-year-olds. And they are having the same problems you are in terms of staffing, in terms of they don't have as many alternatives, placements, but they do have a loss of probation officers in the field due to staffing in facilities and staffing for other reasons. So it's concerning to me that this group won't be served in ways we envisioned. And I'm wondering why the request to 25. I could understand maybe 24. My understanding from yesterday's testimony in the Appropriations Committee, you expect to have something back in line by 2024. And I'm wondering why you're asking for 2025 rather than 2024.
Senator Steers, I think at this point, our primary goal is to defer the 2023 date. In terms of and once we meet the requirements as outlined, if it's before 2025, I'm sure we'd be happy to implement it at that time.
I'd like to echo what Commissioner Chen indicated, and we are trying to work very closely with DOC because I understand your concern, Senator Sears, about the problem being with DOC as well as with us. And I think that really, as we roll out these initiatives that we have, we will begin to create more space, and then we'll be able to have more flexibility to have additional discussions so that that pressure will be alleviated across not just DCF, but at DOC as well.
And would there be any consideration to take the splitting and taking 19-year-olds who have not committed a listed crime or some other subset?
You mean taking them for placement?
No, taking them because they would generally be dealt with in the community anyway. There'd be kids that would end up in diversion, kids that would end up, they'd be now not have a delinquent. You can't predict every case, obviously, but majority of those who are nonviolent offenders would probably end up in community-based programs no matter what you did, which are already available. And I'm just wondering if that would be a consideration as well.
I agree with you absolutely that although we've had a lot of attention on the upper level of youth that have delinquencies and more violent acts, the vast majority of the youth in this population can be served at a lower level. And that's why we're trying to create a more robust array of services so that they can be served within the community or at a lower level. I agree with you.
I'll let the vice chair take over if I can't see whether there's questions of the committee.
Thank you, Dr. Chen. I'm wondering, as I summarize your testimony in my mind, it's that DCF isn't ready for this population, partially due to staffing shortages and other things. So we passed this a couple of years back. We delayed it a year last year. Have there been preparations to provide for this population ongoing? Because that was our assumption, that DCF knew these dates were going to change. So I'm wondering, after your testimony, have there been attempts to put the staffing and services within DCF in place to handle the raise the age population?
I would defer the specific answer to Deputy Commissioner Radke, but what I'd say overall is that the staffing that we have now is barely sufficient for the population we have now, much less planning to expand it. I certainly think there will be kind of similarities between the system that we use now. I mean, obviously, what we're using for an 18-year-old won't be that much different than what we're using for a 19-year-old. So it's mostly creating the capacity, sustaining the capacity, and rebuilding what we've lost.
And I guess, and it's a slightly different question. I understand you saying now you're not prepared. I'm just wondering, have there been attempts to become prepared? Or, a cynic might say that a real cynic might say that there was never a full attempt to fulfill this raise the age vision on the part of your DCF folks if there were no preparations being made. Because if we had decided last year not to postpone, or if we decide this year not to postpone, it would fall to you. So I'm wondering what the planning has looked like.
Right, okay.
Yeah.
Yeah, and so perhaps I could turn it to Deputy Commissioner Radke, but again, I think, to use a euphemism, if you're treading water, then, you have to try to stay afloat. And I think that's a lot of what we've been doing, but I'll
But
turn to
if
it.
you knew years in advance that
Right.
you were going to be treading water, you'd get a noodle or a thing to help.
We're trying.
Okay.
Yeah, absolutely. You're correct, Commissioner, in terms of we have been, we're treading water, and the issue is primarily one of workforce. And we have been making significant strides to not only retain the workforce we have, but also doing things in terms of exit interviews, stay interviews to try to keep the good folks we have, and also trying to make outreach to get new people by standardizing our hiring manuals, just to make sure that we are identifying people that want to come to work at FSD and to provide a better working environment. But at the same time, I understand your point in terms of what other services we've been building for emerging adults. And we have been making some programs for emerging adults. One program in Bennington for individuals that have aged out of foster care, and now they have a place to stay as they're trying to get on their feet. And we also do have another program for those that are rehabilitating over at, I believe, Return House. But we did have to shift our emphasis, because we're treading water, on making sure we have the stabilization of our system of care together before we can continue those efforts full force. So we're really trying to do three things at once, but our focus has to be on ultimate stabilization so that all of our programs can be successful.
Understood, and I thank you. The last question I would have would be, if your proposal is to go to 2025 and we were to go to 2024, I'm guessing that we might be in a similar position next year. Whatever we decide, I would like to avoid that sense that no matter what we decide, we're not going to raise the age, because it was not a decision taken lightly, and it was in service of a different view of how to serve these juveniles. So I guess I would just ask, is DCF committed to making raise the age happen? Full stop, I guess.
Senator, I would just say we'd be happy to say yes, we could do it, and continue our progress as in terms of as one of the first states or the first state to do this. Right now, it would be really short-sighted and from my perspective to do so.
Thank you.
Senator Bohos, yes, question.
Yeah, my question, and I recognize you certainly can't predict the future, but about what number of 18 to 19-year-olds are we talking about? What, who, I mean, I guess my question in this moment, it would be, who are the 19-year-olds that if we did have raised the age last year would have come into your system?
I'm going to turn to Deputy Commissioner Radke.
I would need to get the exact number from Tyler Allen. I do know it's not that it's a large number of 19-year-olds. It's just that the overall impact on our system, because it's so interrelated, that it impacts negatively down the chain to bring in an additional cohort when we're still struggling with what we have right now. So it's not that it's a huge influx, but the numbers we're talking about right now, any addition truly has an impact. But I will get you that number in terms of how many 19-year-olds we're talking about.
Thank you.
Any other questions? Anything else, Doc?
No, again,
Well, Yeah, to those numbers, I wonder if we could find out from corrections how many 19-year-olds they are actually dealing with who are not convicted of a Big 12 offense.
So again, I would just.
That would probably give us the number that's out there. Pretty simply.
I would just say in closing that, we're committed to raise the age. If I had the adequate system right now to do so, we'd be happy to do so. We're obviously trying to strengthen and shore up our system, so we'll be able to do so in the future.
Thank you.
Our next scheduled witness is Lindy Bordeaux, Juvenile Justice Director with the Department of Children and Families.
Good morning, Senator Sears.
Good morning.
Thank you to the committee for having me today. For the record, my name is Lindy Boudreau. As Senator Sears mentioned, I'm the Juvenile Justice Director for DCF Family Services. So my testimony is going to be related to the changes in the youthful offender process as outlined in sections 3 through 6. So to better understand the proposed changes, I wanted to provide a quick overview of the current process by which youth get youthful offender status. So for an example, we have an 18-year-old who's charged with aggravated domestic assault. The charges are filed in family division as a delinquency charge. If the charges are initially filed, in order to seek YO status, the case needs to be transferred to the criminal division. This requires that a hearing to explore the motion to transfer is held in the family division. When the case is transferred to criminal, there's another motion filed requesting that the charges be considered for YO status. This results in the case being then again returned to family division for the first step in the process, which is the youthful offender consideration hearing. At that point, assuming all of the appropriate circumstances exist and the court accepts the case for YO status, it then moves forward for merits hearing. Lastly, assuming merits are found, the disposition hearing is held. At that point, the youth is placed on probation and supervision and support to the youth begins. As you can imagine, this process takes a long time and can be delayed by the lack of available court time or new charges incurred by the youth. Delay can also occur if the youth chooses to exercise their right to have a contested merits hearing and if they wish to contest the disposition proposed by the department. This is the process that we've heard today in previous testimony this week that we've referred to as the ping pong effect. So we have seen youth who have youthful offender cases pending and have decompensated and needed support and stabilization. Our ability to support these youth is limited given the pending nature of the case. DCF does not have a role in the youth's life prior to adjudication. We also see youth who incur new charges while they're awaiting the outcome of their YO case. The delay in time from filing to adjudication places the youth in a holding pattern, which limits supports, limited interruption in their behavior to reduce the risk that they pose to the community, and an inability to address the factors that are contributing to their risks. This is an unfortunate consequence of the current process for seeking youthful offender status. In 2018, the law changed to allow young adults through the age of 21 to seek YO status. Previously, eligibility ended when the youth turned 18 as far as being able to seek YO status. Supervision has always continued up to the age of 22. At that time, we were not certain what the impact of the changes would be on the number of youthful offender filings. And what resulted was a significant increase in the filings and an increase in the amount of time to process the case. So I have a quick chart here that I'll try to share.
I'll do it.
Okay, thank you, Peggy.
Find it.
Great. I just wanted to demonstrate just to show you the number of filings of youthful offender and the increase from the changes in 2018, and also the subsequent increase in the amount of time to process the cases. So as you can see in FY28, this is prior to the changes going into effect. We had only 33 youthful offender filings in the entire state. Just for some more context, that was traditionally the number that the youthful offender cases stayed at from the time that youthful offender was created. You can see that it took about the average was 78 days to get from the time of filing to get through disposition. This not only was the change made around eligibility for youthful offender status, but at that point, we also had a system where youth engaged in a conditional plea to be able to be offered youthful offender status. So that was a significant difference as well. FY 2019, this is when the changes went into effect around eligibility, and you can see we had a significant increase to 504 filings in that 1 year time frame. The numbers have dropped off, but they continue to remain fairly high. So you can see that the amount of time to process has grown over that period of time. FY 22 and 23, the first half, there's still a lot of cases that haven't made it through disposition. So I included the numbers here, but it's still a lot of cases that still haven't even made it through the process. Thank you, Peggy. So having a lengthy amount of time from the time of the offense to intervention reduces.
Before we go any further
Sorry.
there, I do have a comment. And I think that's a positive that those numbers are as high as they are. I'm not disagreeing that there's problems with the implementation of youthful offender and what I've heard about, the ping pong and the amount of time, et cetera. But I think it's a positive that more people are taking advantage of the opportunity where we know that the recidivism rate amongst this age group is amongst the highest of any age cohort. So it seems to me if even half of them are being successful, that's a really positive thing. And one of my concerns is if we make significant changes in the process, that we'll be back to where very few people take advantage of youthful offenders. So I realize it creates an extra burden on the department, but I think it's a positive that more people are taking advantage of it.
Yeah,
That's just a comment from my perspective.
No, I appreciate that, Senator Sears. And just to be clear, the department's position is not to make changes to reduce workload for the department. Although the change in process certainly did result in 2 additional hearings and a lengthier process, the concern is really around.
No, a lengthy process doesn't do anybody any good.
Exactly.
Particularly the person who's the subject of the youthful offender status. I was merely pointing out that there's a huge benefit both to the community as well as to the offender when they can take advantage of youthful offender status. And I think it's a thing.
Yeah, no, we certainly agree. And I do think that, the department continues to be committed to providing opportunities for youth to have less collateral consequences as a result, and youthful offender certainly does that. I read all of the youthful offender reports and edit them before they're filed. So I see that we do have youth who may make a mistake and have youthful offender status, and that happens again and again for them. So this is something that is afforded to youth over and over again. And those youth, even though they may get a new charge, they may still be successful in the end. So we certainly appreciate those comments. As I was saying, having a lengthy amount of time from the time of the offense to intervention reduces the effectiveness of the intervention and the opportunities to support the youth, delays the ability to address the concerns of the victim and to protect the public. Additionally, there are youth who lose the opportunity to benefit from YO status due to the fact that there's not enough time to engage in the services being recommended before they turn 22. As I just mentioned, I do read all the reports, and I've seen many cases where the youth are nearing the age of 22, which is when jurisdiction ends for youthful offender supervision. And because of the lag in court time, we're in a position to really hope that the court will afford them the opportunity to have quick resolution so that they can benefit from youthful offender status. The changes that we're proposing would reduce the time frame and hopefully reduce that problem. So the proposed legislation centers the juvenile justice system on serving youth and emerging adults based on best practice and evidence. The proposed changes refocus the system on serving youth by streamlining the process, increasing efficiency, and providing clarity to the juveniles interacting with the justice system. Moving to a process where while youthful offender cases that are directly filed or motion for youthful offender treatment are filed and remain in criminal division as sealed cases reduces the ping pong effect that's currently present and provides a quicker resolution to the case for the victim, the community, and the youth. The sealed status of the cases would afford confidentiality to the youth, as is currently the case in family division. This would eliminate the collateral consequences of having a criminal record, because once they're flagged as YO cases, they would be treated differently than other cases filed in the criminal division. Excuse me, another aspect of the proposed legislation is to return to the practice of having the youth enter a conditional plea of guilty in order to be considered for YO status. This practice would cut down the amount of time needed to get from filing to disposition by eliminating the need for the court to hold the YO consideration hearing and the merits hearing. The process would result in the case moving directly to a disposition hearing following the acceptance of the conditional plea by the court. The court would use the same criteria to determine YO acceptance, so concerns about public safety, amenability to treatment, and service availability in the juvenile system would still be explored. The process would still allow for victim participation at all hearings. Given the fact that YO cases would be sealed, prior concerns about having a conditional plea of guilty while under YO supervision would be addressed. In previous practice, that had a negative impact on youth, and these changes would address that and hopefully eliminate that need. So this information would not be accessible to the public. Therefore, those potential negative consequences would not be there. Are there questions?
Do you have any cases where treatment has been delayed because the youth was not willing to admit to the crime?
We certainly have had cases where, for youth in our custody, we've had cases where we're not able to provide the recommended treatment, residential treatment for youth, because they're pre-adjudication status. So yes, there has been times when, because the youth does not have that status, we're not able to send them out of state, for example, to the residential treatment that is being deemed necessary for them.
Thank you.
Other questions?
Not seeing any questions in the room.
Okay, good.
Great.
Thank you very much.
You're welcome. Thank you for having me.
Is Eric there?
Yep.
Oh, we have Tucker Jones next. Sorry, Tucker.
Mr. Chair, it's okay. I'm here this morning primarily to talk about the Title 18 provisions that we had put forward, and it's really somewhat different from the juvenile jurisdiction that we're really talking about now. And I saw earlier this week that you may be just interested in addressing that separately.
Well, we've got, I think I'm going to try to go over the list, but I think there's 5 or 6 different bills that are being either in the drafting stage or we're dealing with. And one of them would be those sections dealing with drugs that you've proposed. And I believe Eric is currently drafting that. We have the forensic facility bill. We have the competency standards bill. And then I believe I'm missing one bill that has, the hospital violence bill that we're taking up next week. So there's like 5 or 6 different bills rather than one big one. And this is the more of a, I appreciate that. We will have you in on that other bill.
Well, I'm happy to come back on the Title 18 proposals when that bill gets taken up. And I just didn't want to take us off track from the juvenile jurisdiction conversation. Yep. And I just noticed Jared and State's Attorney Marthage are here. And I wasn't sure if they were planning to.
I believe they're planning to, I'm not sure what they're.
I would just defer to them if they wanted to speak to any of the subject matter that's been discussed so far.
Well, I will offer them time. Erica or Jared, do you want to comment on any of the
Thank you,
subject
sir.
matter?
Yeah, I'm happy to share some comments with the committee. Thank you, Mr. Chairman and members, for offering us that time. If you'll bear with me for 1 second, I do have a bit of a PowerPoint presentation to walk through. I'm not as familiar with Zoom as I would hope to be.
And what's the we didn't have you on the schedule, so what is the subject you're discussing?
It would be concerning, sir. It would be concerning.
Okay, good. Yeah, go ahead.
And what I wanted to do, if I can, is I hope this is working correctly.
It looks that way.
Great. So my comments concern S4. And I do want to thank the committee for giving me the opportunity to make these comments. We do ask that you pass this important piece of legislation together with the administration's proposed amendments. We think those strengthen an already important piece of legislation. The first question I wanted to answer is, so who am I? Why am I talking to you about this? My name's Jared Bianchi. I'm a deputy state's attorney from Bennington County. I spent the first 9 or so years of my legal career at the Attorney General's office, representing the Agency of Human Services and its constituent departments. That includes the Department of Mental Health, DALE, the Department for Children and Families, DOC. Within those years, I've sort of been through the whole agency. More recently, I moved to Bennington County, where I was glad to have the opportunity to join Erica's office at the state's attorneys. Part of my responsibilities there are the juvenile docket and also very serious drug-related felonies. And part of the reason that came to be was because the degree to which those two dockets overlap. They overlap in very obvious ways, like the young people that we've been talking about who may become defendants in cases, but they also do so in ways that are not as obvious. I'm thinking particularly about Chin's cases that I've seen where, part of the reason that we are involved with the family is because some violent drug gangs have been breaking into their home and threatening the family with guns while the children hide under the bed. Or truancies, where it turns out that the child is truant because she wants to stay home with her younger sister because gang members and drug dealers have essentially taken over the home, and she needs to be there to provide protection. So it's against that backdrop that we're having these conversations, and we really appreciate you, Senator Sears, and the sponsors. We do feel that as a state, we need to be proactive and prompt as we address these issues before they become as entrenched as they are even in some of our neighboring states. And I do want to invite you all to please stop me along the way with any questions. One of my chief intentions here is to sort of walk through the sections of the bill and talk about how those resonate with our experiences in Bennington. And I'm not sure if Tim Lueders-Dumont is there, but I think that he would be willing to say that this is not unique to Bennington County. This is happening everywhere. So the first section 1, we do feel is important. It's important in a couple ways, and I know that it's been talked about a lot because it expands the ability to access the criminal system for an age group who we would not have been able to do so. But that's also important because it also expands access to direct filing of youthful offender. Currently, I cannot file a youthful offender petition unless I could otherwise file a criminal case against the defendant. Right now, that's limited to the Big 12. We believe that the expanded list that the bill provides, and especially the expanded list that the administration has suggested, sort of move away from a one-size-fits-all approach. We need to be looking at these really serious cases individually and addressing their needs on the basis of the case, on the basis of the defendants, and on the needs of the community. So this does not foreclose youthful offender options going forward, even if we were to utilize that criminal process to begin. And the way that I would describe that, in my experience, is we need to be able to address an immediate public safety concern at the time. And the best place to do that, really the only place to do that, is in the criminal division. But if the outcome, if the sentence or the disposition should be something that is more reflective of a person's young age, indiscretions, whatever the case may be, nothing is off the table with respect to outcome. But for a lot of these, especially high needs, high risk juveniles, we need the structure and the accountability that the criminal division provides while we get to that point.
Jared, can I interrupt you real quick and ask a question? I'm just trying to grasp the balance between the first point here under the two impacts that you're listing, which is expanded access to youthful offender, and then also the conversation about using the criminal court to have a greater impact on crime. It is, and I'm not trying to put words in your mouth, but that's what I'm getting from the testimony. Can you, can you just explain why you think that there will be expanded access to the youthful offenders?
Absolutely. So youthful offender is available right now if the prosecutor could otherwise file it as a criminal charge. Right now, other than the Big 12, I am not permitted to file anything as a criminal charge for a person who is under the ages of 19. By expanding that list, not only am I able to, if appropriate, utilize the criminal division, but I'm also able to directly file a youthful offender for that expanded list. And I would use, for instance, human trafficking. Right now, I would have to file a human trafficking charge as a delinquency, and then wait sometimes as long as 11 months or so before we figure out which case it will proceed in. Certainly somebody engaged in human trafficking is a person who we want to be treating with an eye toward seriousness. So this would allow me to, first of all, file that as a criminal charge, and then if appropriate, convert it to a youthful offender, or have the defendant make that request as well. Or I could direct file, and I have direct filed youthful offenders for crimes as serious as sexual assault, various serious sexual assaults.
And one more question, if you don't mind. We've been hearing a lot about court backlogs, and one of the issues has to do with just the amount of hearings and the amount of motions that are getting submitted. Do you feel that, as this is written, this would increase the number of hearings that would have to be held, or what are your thoughts on that?
I believe that the administration's proposed edits do address that. There's really no special need to be transferring back and forth between courts for the types of cases that we're talking about today. I have cases that I'll be talking to you about later on that it has taken. I believe the raid on the home in question was in November of 2021, and we have only recently resolved where that case should even proceed. That's not a system that's serving that defendant well, or the state, or the people in the community. So I think, especially with those modifications that have been set forward by the administration, we would have a streamlined process that both meets the aims and the needs of the youth who could become criminally involved, and also satisfies, I think, the intentions of the program.
Well, my obvious question would be, why not allow all three? If we're opening up the toolbox, why not allow you to file as either criminal, youthful offender, or delinquent?
And I think anytime that we're talking about allowing a case to be assessed individually, and to allow people who do this to exercise judgment, I think that's the right call. So there is no reason that you couldn't do that. I think the problem is, right now we are stuck in a very ill-fitting one-size-fits-all.
Yeah, I understand the process. Used to be Bennington County was the only that actually did much youthful offender work, and that was because of Erica's interest in it and Erica's understanding of the benefit of it. And then we changed the law, and we saw more people using youthful offender. And that's my biggest concern about these changes, is that we'll have fewer youthful offender.
I do not expect that, Senator. I expect that this will get people where they need to be much more promptly, I don't think that the population will be impacted because at the end of the day, if the person is going to be utilizing youthful offender, that's the adjudicative process. Oftentimes, the way that it is now, we are talking about, sentencing an outcome before we have a resolution of the factual dispute.
Well, the younger you are, the quicker the resolution is, the better off everybody is.
And that is true. One thing that I did want to note on the expanded list that the administration provided is that it includes something that we have felt is critical and has been a real issue in cases recently, that in a case that is currently in the criminal division for people under the age of 19, if the criminal division sets conditions of release, we cannot file those violations of of conditions of release with the criminal division. In other words, the court that sets the conditions can't address the violations. So we think it's really important that however this committee moves forward, that the committee be aware that the conditions of release should be addressed by the court that sets them. And we hope that this will be a remedy to that. Our experience in this area, I'll point to an example, is a raid that happened on Gage Street in Bennington, which is right downtown. The law enforcement were aware that this house was being used to traffic narcotics out of, executed a search warrant on the home where they found a mother, a child, and numerous young adults, as young as, I believe, 18. The 18-year-old in question had a gun on him, tried to run. Several of the other young people, I believe also in the 18 or 19-year-old age range, had possessions of weapons and thousands of bags of fentanyl and crack cocaine. Those individuals, of course, where they would be prosecuted became unclear, and we have taken, I think a year or so or more at this point. This is an ongoing discussion. It has taken us, over a year to even figure out which court these would proceed in. And then we have the additional issue that if we file, for instance, a fentanyl trafficking and possession of a firearm charge against a young person, they begin as a delinquency. We have to then file a motion to transfer them up, and then it has to be, and then they can file a motion for youthful offender, which has to go back down. And in each of these instances, there are essentially overlapping hearings that have to occur, but can't really, unless they're willing to waive them, really be skipped. And I want to take an opportunity to make you aware of MB, who was in that home, that Gage Street home that I'm talking about. We weren't aware of the degree of what was going on in the home before MB bravely came forward after she was able to leave that home. And I won't read these pages all to you, but I hope you will take the opportunity to look at these slides, because what they talk about is something that unfortunately we have seen in several instances. It is groups of, relatively young, I would say young adult, of folks who come to the community. They identify people who are vulnerable due to their addiction. They gain entry into the home, and then they slowly begin to take it over. And what MB told us about was a situation where they came in, they refused to leave, they began inviting more and more people. She's watching them cook crack cocaine in the kitchen, numerous sales of drugs, and anytime that the family who really lived there tried to assert any control, they were threatened with the firearms that were many firearms in the house, that they were video monitored, that they used up the heat, and all the while they were essentially confined to their rooms while the parent paid, a pittance in narcotics. So these are the experiences that we come to this legislation with. With respect to sections 2 and 3, I know that you've heard some testimony on these and some concerns. What 2 and 3 address are criminal negligence. Landlords have tools besides eviction to ensure that they are not criminally negligent with the way that they are managing their properties. We have, there are options for simply being aware of what's going on, security cameras, property managers, lease provisions, law enforcement reports, and I think an especially creative version was provided by Defender General Valerio when he pointed out that he was able to investigate some concerns that were going on.
Yeah, she wasn't.
A person who does not have reason to know that something is going on and is making reasonable efforts to ensure that their property is safe, it can't really be said to be acting recklessly. So I want you to think critically when you hear these concerns that just people who are otherwise doing nothing could somehow get swept up in a dragnet. That's not the case. What the issue is, though, is that a landlord who ignores their property to avoid responsibility or ignores information that should cause one to act, they are acting negligently, and they're not an innocent third party. They're part of the problem. And any of the concerns you have heard could be addressed by simply including affirmative defenses. Things like making sure that the police are aware of concerns, undertaking to evict, things like that could be considered affirmative defenses.
Jared, can I interrupt you real quick?
Yes.
Just for the rest of the committee, can you share what an affirmative defense is and what sort of utility it has?
An affirmative defense, and just by way of example, insanity is an affirmative defense that says, the facts are not really at issue here, but I'm not responsible for this crime because. So in this situation, you could say, I'm not criminally negligent. I've already, taken the following measures to secure my property, such as, instituting an eviction proceeding. And I do think it's important for the committee to be aware that I believe it's Title IX.
Other information is really,
I'm sorry?
one video, it can load them up. I just did it.
And I'm sorry, I couldn't quite hear that if that was a question.
I think there was just some interference. You can continue, Jared. Thank you.
Sorry. So there is an expedited eviction process for safety and drug-related concerns. So while it is true that a general eviction process can take an especially long period of time, that the institution of that process, first of all, could be included as an affirmative defense, saying I've done everything I can. I'm not, criminally negligent, but also that the committee should be aware that there is an expedited process to address these particular types of concerns. And so I'll share a little bit about our experience with the types of properties that we're talking about. We have a property on 546 Main Street. This is directly across from a popular pizza restaurant. It is it is in the downtown shopping areas, and it has become a routine target of police search warrants because violence and drug trafficking has become obvious there. So this is the picture that you're viewing here. That's the result of the third search warrant executed on the property. We've taken out probably a dozen various dealers and folks out of that property. There are numerous charges, and all the while the landlord did nothing. We recently, in trying to address this, began to utilize a civil process, but the outcome of that civil process is not known yet. And it does, of course, like most civil litigation, take additional time and resources that are not really within the standard state's attorney's budget or processes. What we saw here was a landlord who resided in Florida, had reason to know and was aware of some of these search warrants and simply did nothing. And I can say that this house has only been on offline, and maybe as recently as this past October. We continued to get problems there even after the resident had moved out because it had become so well known as a meeting spot and a spot for drug dealing. At no point did the landlord make any efforts from as far back as the beginning of last year that he became aware of these concerns. So only once. Yes, sir.
I'm sorry to keep interrupting you here. I just want to make sure I clarify some things. So taking steps, taking measures, would that include something as simple as just calling the police to say, I'm a landlord, I own X, Y, and Z property, I have concerns about some issues that are going on? Is that something that you would take into consideration when you're looking at a case?
We absolutely would take that into consideration. And we actually saw, after we filed even our civil case against this 546 Main Street property, people doing that. Landlords were calling and saying, hey, I'm aware of this case about 546. I just want to let you know that I have these concerns. I don't want any problems. And we really appreciate that community partnership. But we do sometimes need to inspire people to be our partners in a way that gets them out of simply walking through things. And that's, I think, what this did. And I think that's what this legislation would do in a really clear way.
Out of
So
curiosity, what was the civil case that you filed?
the name of it?
Just what was the basis for it?
So there is in Title 18 a provision concerning a common nuisance as a result of drug houses. And so we are in the process of trying to have the property declared a common nuisance, to have some injunctive relief and some penalties imposed. But it is not a frequently utilized tool, if at all. And so we are sort of walking through fresh snow with respect to that suit.
Thank you.
I want to talk a little bit, if I could, about Section 4. We've heard some conversations from some folks that, simply possessing a gun or some of these other things, those aren't inherently, crimes of violence. And I would say, defaced serial numbers are for one thing only. They are to evade responsibility and detection for an act of violence. This is a weapon that you're looking at that was taken out of a car, I believe on Union Street, also downtown. A concerned citizen called when they saw a person putting this into their trunk. Not shown as the extended magazine. This is a AR style semi-automatic 12 gauge with a removed serial number taken from a drug dealer who on his person, he was found outside the car, had a fanny pack with another gun on him and numerous bags of fentanyl. So, this is what we're talking about. We're not talking about, the hunting 22. We're not talking about somebody who's got a hunting rifle in the back of their car. This is people who believe that they will be engaged in violence and are taking steps to evade detection for being engaged in violence. And I'm not sure, I'm nervous that I'm not going to be able to share the sound of my screen. But as I'm going to share with you a video of a shootout that occurred on 715 Main Street. This is also downtown in Bennington. And I think some things that are important are that the video that I'm going to show you is from a sound activated camera, which means the shooting started, in talking with law enforcement, it means the shooting started before the camera began to activate. The shooters here were as young as 18, and during the investigation, ghost guns were recovered next to a children's play area next to this house. And I'll note, I think there's been some conversation that, that a lot of this is simply mirrors federal law. You should be aware that ghost guns are not as robustly addressed by federal law because those federal laws depend on interstate commerce. And ghost guns are really hard to prove that they've traveled in interstate commerce. So you as the state's representatives have an outsized role with respect to that question. And if anybody knows, especially how to share sound, here we are.
I think if you play it and it comes out of your speakers, we should be able to hear it, shouldn't we?
Yeah, and I'm hitting play, but it's not working especially well at the moment. What I may do is come back to that because I don't want to delay. But what this video depicts is a shootout between two rival groups of drug dealers, some of whom were inside this home, several of whom were outside of the home, and they're exchanging gunfire on Main Street. And then as they leave the residence, they are throwing their ghost guns next to a children's play area, which thankfully were not recovered by any children.
There we go.
And so this is what we're seeing in Bennington. And again, I do believe these issues are not unique to Bennington by any means, unfortunately. With respect to Section 5, I wanted to highlight a couple quick points. One, straw purchasing contributes to human trafficking. We will often see that these vulnerable victims of human trafficking who are vulnerable because of their drug addiction, for instance, may have a less pronounced criminal record, if any, especially when they're younger. And so they will be employed or required to engage in straw purchasing for the trafficker. I know that there has been a concern that we didn't want to get victims caught up as defendants, and we agree with that. But I do think it's important to note that there needs to be an entry into contact with a system of services, and sometimes that entry point is the criminal justice system. In Bennington, we're proud to have a human trafficking victims advocate right there at the Bennington Police Department, and it is very frequent that our trafficking victims are also defendants on some dockets. And so I think that this highlights the need to recognize that sometimes the entry point to services is the criminal justice system, but that doesn't need to be the resolution. It should also be noted that for that trafficker, the person who's not doing the purchasing, that the state does have the ability, if there were an offense to prosecute, to charge that person as an accessory before the fact, which means that they are as responsible as the person who did the straw purchasing for that felony. The important part to note here is that we need not charge the purchaser in order to charge an accessory before the fact. So, we will have some flexibilities to look at the real facts of the case and to charge appropriately and do what we need to do. But we do think it's an important tool to be able to have. I did also thought it would be helpful to note for you that, a person right now in Vermont can serve a sentence for murder, be released, have a person straw purchase a gun for them, take off the serial number, and walk around with it. And that amounts to, under current law, about one single misdemeanor of not being allowed to possess a firearm. Section 7, I think this is a really important section. I think we've heard some concerns that, we don't want to catch people up unnecessarily in some sort of hold without bail situation. What this section does is it allows the prosecutors to make that request. It doesn't mean that it will happen, and it doesn't mean that it will always be made. It simply allows the conversation to happen, and if that conversation does happen, substantial process attaches to it, and a judge decides. We heard some concern about, the hunter DUI-4 with a rifle in his truck, or a kid with a box cutter in his pocket on the way home from work engaged in some other minor misdeed. Nobody in the prosecutor's offices that I'm aware of is ever would want to seek a hold without bail in those situations. But more importantly, even if somebody did, there are substantial checks and balances and considerable hearings that need to occur to ensure that that remains appropriate. It's the judge who decides what happens. This simply allows us to have that conversation. Nothing about this bill would require us to leave our judgment or our senses at the door about what we're trying to accomplish. And I wanted to share some experiences in Bennington. And these are experiences I told you about before. Gage Street, where we had those numerous people that MB finally came forward and told us about what was going on after the fact. Most of those people could not be held without bail, despite sitting in rooms full of narcotics and guns and having apparently been threatening people with them. A lot of those people, we simply couldn't even make the request. And that means that we don't have control of the situation to ensure that witnesses and the like are protected and that they won't flee from prosecution. We recently also did several search warrants at Beach and McCall Streets that included young people as young as 16 who were noted by even the adults who were also arrested as being especially violent. They were found with thousands of bags of fentanyl, and the person who we believe is the head of the gang, if you will, is 18 years old. He was not able to be held without bail despite the fact that he was throwing a bag full of guns out the bathroom window and trying to jump out of it when the police executed the warrant. The large weapon that you saw before with the defaced serial number, who was also had a fanny pack, the owner of which, Mr. Morgan, also had a fanny pack with a gun and fentanyl in it. He was not able to be even, we couldn't even ask for him to be held without bail. You know, who knows what could have happened with that, that cannon that he had on him, but we were not able to even ask for him to be held without bail. And he was, you know, these folks can return to the community and make sure that everybody knows that law enforcement can't keep them safe. So we think it's important to at least be able to have these conversations, make these requests, and to let the judge decide if that's the right path forward. But we do ask for that flexibility to be able to address these very real concerns. I really appreciate your willingness to hear me today. We do ask that the committee pass this important piece of legislation and include the administration's proposed amendments and really show the kind of bravery that MB did when she came forward to try and address these concerns. Thank you very much.
Thank you. Are there further questions for Jared or anyone, or Erica Mathich?
Not seeing any.
I appreciate the testimony, Jared. I have some concerns again about the administration proposal and expansion of the Big 12 to what might amount to the Big 29 or whatever the number is. And I'm trying to understand some of the crimes that they've suggested be included. And I am, you know, I have concerns about aggravated domestic violence. I have concerns about some of the other crimes. Because once we go down that road, you're asking us to trust prosecutors, and yet, you know, we do receive complaints about various justice systems around the state, and you have the experience of having worked for the state agency of human services, where you sort of saw disparities between perhaps Chittenden County and, let's use Windham County for an example, in how charges are brought, what charges are done. That does concern this committee, and I wonder if you could comment on that.
I'd be happy to. First, I think if you go down that list, I want you to think again that each of those expanded lists, that represents the opportunity to only have this conversation. It's not some authority, a final decision maker that the prosecutor would be having. It's something in the toolbox that we can raise with the defense attorneys, with the judge, to make sure that what is happening here is appropriate, both for the defendant, for the state, but also for the community. So in each of those instances, there very well could be situations that we would not, and I use, for example, a case that I have pending now. It's a sexual assault of a very serious nature. That was direct filed as YO. We would be able to continue making those decisions under this expanded list, but it also includes, there could be fact patterns where unquestionably, we at least need to begin the process to have the tools provided by the criminal division. I would also note that when we're talking about some of the approaches of different counties, you know, each of those counties are communities, and they have the opportunity to vote about how their elected representatives and their elected state's attorneys are doing things. So certainly we do want to see, we don't want to be seeing inappropriate disparities, but to the extent that one county may have a different approach, the voters get to decide who is making those decisions, and that's reflective of those communities. That's the nature of the democracy that we are lucky to have. But we can't keep those communities safe if we don't at least have that toolbox available to have those conversations with the judge about what the right thing to do is.
What about the argument that once you open the box, even if you go YO, or even if we allow the choice of YO, delinquent or criminal, once you've opened the box in criminal court, the matter is now public. And so the name is Google, I don't know, I was reading the banner this morning, or somebody, some defense attorney was talking about the Facebook jury on the front page of the banner. I don't know if you had not read that article, but it was an interesting article in that now it's all public about this individual. And one of the benefits of youthful offender, one of the benefits of delinquency is that it's not a public document. Once you've opened that up, beginning, people will be able to Google it. So even though the court proceedings and everything will not be public, the name is out there. Any response to that from either of you, either Eric or yourself?
Well, first, I'd like to defer to State's Attorney Marthage.
Yeah,
And you may want to talk about Facebook juries too. I don't know if you read that.
Yeah, thank you. I would for two simple reasons. Facebook juries, Twitter, social media, police blogs, those are all out there anyway. It has absolutely nothing to do with what our court system is doing one way or another. I'm sure you know, Senator, there have been multiple times where I'm actually hearing about what offenses have happened in my county through social media, not from the police. It hasn't even made its way from the police to me yet. So, you know, I don't think that the change in the statute for a youthful offender would have any impact on the ultimate Google ability or whatever, you know, whether you can look something up. Particularly with 18 and 19-year-olds, because law enforcement does those as press releases, particularly VSP. They do a press release for all 18 and 19-year-olds. Doesn't matter whether they would be youthful offender or not. I just wanted to back up as well on what Jared was talking about with the, look, youthful offender, when we were using it the most successfully, was starting with the state's attorney and making that initial referral or that initial suggestion. And the reason I was so vocal about getting it out there as an option was because I was seeing that defense attorneys didn't know about it, didn't utilize it, didn't know that it was even a possibility. So the idea that now giving that referral authority or referral ability back to the state's attorney's offices does nothing to change what cases would be referred and which ones would be more appropriate. And if you look at it this way, the current legislation prevents the state's attorney from doing their job. It prevents me from referring the people that I think really need to be youthful offender and would benefit from it. It doesn't prevent the defense attorney from continuing to do their job. It ultimately is still sitting with the judge. The defense attorney is going to make all the same arguments that they would make whether I'm doing the referral or it's automatic. The only thing that's happening now is it's preventing me from making that direct referral, making that happen quicker. When Lindy was talking about the numbers earlier, yeah, I would say that a fair number of that 500 referrals that have been made, I would be really curious to see how many of those referrals were ultimately treated as youthful offenders with the stamp of approval from the judge. Because I know what we see in Bennington is ludicrous situations that are being, suggested that we should be doing youthful offender on offenders that are not even remotely amenable to treatment, have lengthy criminal histories in another state, but yet we're looking at, we should be treating them as a juvenile just because that's what the statute says. So I would be curious, that 500 number, I don't think you're going to see kids, youth, emerging youth, not going into youthful offender with the change in legislation. I think what you're going to do is you're going to see all the cases that we're, spinning our wheels on, unable to make progress. Those are the cases that are going to be not addressed. I think that would be the decrease that you would say. Not that state attorneys don't want to use it. Plus, I just would point out a lot of the information that you have received to date about the practices of state's attorneys. As Jared said, the electorate has, exercised their right, and the state's attorney's department has turned over in a significant number. Point being, I'm the senior state's attorney now, and I know I'm too young for that. So
yes, you are.
So it definitely has been like some major change has occurred statewide. So I think I am going to be speaking with Marshall Paul about, I know it was suggested last week that we have a conversation. Maybe we can come to a meeting of the minds. I am happy to look at anything that Marshall drafts over the weekend. I want to see youthful offender back to what I consider its heyday when I used to use it all the time. And it was great. And now it's just not.
Thank you. Any other questions? And thank you, Erica. I appreciate your willingness to work with Marshall on this and his willingness to work. And I know the two of you are both committed to youthful offender legislation as long as I've known you, which I don't want to age you by saying how long that's been. I thank you both very much. Are there any other questions or comments?
Nothing in the room.
All right, it's been very helpful. Eric, I just want to make clear to people that next Friday, the witness that we have from Duke University is not a proponent one way or the other, but merely providing us with information about cases that have been affected by the Braun decision by the U.S. Supreme Court. That we're not looking for one side or the other here. It's more of a thing from our own legislative council. Is that correct?
Yeah, I think that's right, Senator Sears. If he holds himself out as an expert in Second Amendment law who can help the committee understand Bruin and the cases that have been decided since then and what the legal pattern is, I don't understand him to be an advocate one way or the other.
Right. Thank you. We're going to continue next Wednesday. We will be having a joint hearing with the Health and Welfare Committee. So be prepared to head down to the pavilion. He will have the location for us. But that's where we're going to hold the joint meeting. And it's on hospital violence. And we'll be mainly hearing testimony from people who about some of the violence going on in our hospitals. Maybe I know I met with folks from my emergency room and heard quite and so that's the subject of it. It's has that bill been introduced, Eric? It's S something or other.
Yeah, I think it's S36.
S36, yeah. And just as one other housekeeping before we take a break, I think half of the bills that have been introduced so far in the Senate are in this committee. And so if you have a particular interest in a bill that's been introduced, please talk to either Nader or myself about making sure it gets on the agenda, because we're not even going to get to all the bills that have already been sent here, not to speak of the ones that we haven't gotten. So we try to put together an agenda every Thursday morning. So just be aware of that. I know Senator Baruch said in the beginning it'd be nice to take up all the bills that are introduced by various senators. I just don't see how we do it here. So with that, why don't we take a break till 11:15?